क्या भैया? रूममेट से पूछना जाके हैं। तो ये क्या है? ये है जो रैशनैलिटी, द ग्राउंड ऑन विच द जजमेंट हैज बीन गिवन, कि भाई जो बेसिस था जजमेंट का वो क्या है, राइट? द कोर फिलॉसफी, द कोर वैल्यू, द कोर फ्रेमवर्क, द कोर बेसिस ऑफ द जजमेंट, व्हाट वाज दैट? रैशनैलिटी क्या थी, लॉजिक क्या था, राइट? रेशियो डेसिडेंडाई, जैसे आप यूज करते भाई लोकस स्टैंडर्ड। तो व्हाट इज द बेसिस ऑफ पिटीशन? आप क्यों ये केस फाइल करते हैं? हाउ आर यू अफेक्टेड? आर यू इन्वॉल्व? आर यू पार्ट ऑफ दिस, राइट? डू यू इन एनी वे सीक compensation through this? Are you affected party or not? Well, I'm not affected, so the court will say you have no locus standi, don't file the case. Why are you filing this case, right, on behalf of उर्फी जावेद? Why should you do that? क्या करना है आपको उससे? उसको कपड़े पहनने दो जैसे पहनने हैं, बट तुम कंसर्न हो कि वैसे कपड़े पहने, राइट? लॉजिक ये नहीं सी, when you are, this is the standard procedure. PIL is not a procedure, first understand that. The standard legal procedure is this. If you don't have a stand, you cannot fight, right? अब आप चाहते हो कि no, I don't have a stand, but still I will file the case on behalf of someone, on behalf of something मुझे करना है, fine? मैं प्रशांत भूषण हूँ, मुझे करना है कुछ ना कुछ, fine? So क्या होगा? Then you will say कि fine, I am filing the case not through a procedure, not through the established procedure, but I am filing a case through an alternative procedure called PIL. That is why you have to distinguish between PIL and non-PIL. No? Everything cannot be PIL. तो प्रोसीजर की क्या वैल्यू अगर सब कुछ PIL ही बन जाएगा तो? समझे ना? उसका भी तरीका है बच्चे कि सब्सटेंशियल ग्राउंड क्लियर होना चाहिए कि भाई आई एम फाइलिंग द PIL, देयर इज अ स्पेशल public interest which is being violated, which gets affected, right? That is why it is called public interest litigation, social action litigation, collective interest litigation. PIL, SAL, CIL तीनों बोला जाता है इसको। तो जो फाइनल जजमेंट होता है भाई, उसका जो फिल्टर्ड वर्जन है, उसकी जो रैशनैलिटी है वो ये है। आपका स्टेक क्या है, व्हाट इज हाउ यू आर अफेक्टेड पार्टी, वो ये है, राइट? ये जो है एक्चुअल जजमेंट है, जो है ये जो है पेरिफेरल ऑब्जर्वेशंस हैं ऑफ जजमेंट के, राइट? तो कोर्ट के पास बहुत सारे, व्हेनेवर द कोर्ट गिव्स एन इंस्ट्रक्शन, ठीक है, जैसे वी यूज द वर्ड डिक्री ऑफ अ कोर्ट। व्हाट इज डिक्री ऑफ अ कोर्ट? आई हैव आस्क्ड यू आल्सो। I remember everything. That's a big problem. So you cannot be left, right, without scrutiny. नहीं, ठीक है। फाइनेंस कमीशन, उसको अवार्ड्स बोले जाते हैं, राइट? अवार्ड और डिक्री मोर और लेस सेम माना जा सकता है। सिविल कोर्ट्स, right? Obviously, when civil courts are not like criminal courts, they cannot give you punishment, they cannot force something on you, try to understand. But civil courts give fines, right? Impose fines, defamation case, civil defamation case, and likewise. तो जब civil courts कोई judgment देते हैं, right, which almost has the impact of being enforceable, or judgment. Correct. Authoritative order, but yes, generally the word decree is used for civil courts, administrative bodies, quasi-judicial bodies, and likewise. For criminal courts, right, or for higher courts, technically, whatever they give, right, it becomes a kind of judgment. Understanding? So when you use the word enforceability with respect to certain judgment given, but by civil courts or other bodies like that, which are non-criminal in nature, then we use the word decree or award. ठीक है, तो वी कैन से सिविल कोर्ट हैज अवॉर्डेड द पनिशमेंट। अब सिविल कोर्ट पनिशमेंट थोड़ा देता है, बट हम उस फाइन को, इंपोजिशन ऑफ फाइन को पनिशमेंट मानते हैं। तो जनरल टर्म पनिशमेंट तो सही है वहां पे, नथिंग रॉन्ग इन दैट, कि भाई ही वाज पनिश्ड बाय अ फाइन और पनिश्ड बाय दिस। सो क्रिमिनल कोर्ट के पास राइट है कि वो इंपोज कर सकता है क्या, इम्प्रिजनमेंट, पनिशमेंट। नाउ सी मेनी ऑफ द लॉज सेज कि फाइन ऑफ दिस मच और पनिशमेंट ऑफ दिस मच, और फाइन एंड पनिशमेंट बोथ, imprisonment of 3 months और फाइन ऑफ 1000 rupees और बोथ। अब फाइन कौन इंपोज करेगा? सिविल जज। फाइन तो सिविल नेचर में है ना भाई, और पनिश इंप्रिजनमेंट कौन भेजेगा? क्रिमिनल जज। तो उसके बिहाफ पे डिस्ट्रिक्ट सिविल जज, डिस्ट्रिक्ट सेशंस एंड क्रिमिनल जज, उनके बेसिस पे जो लोअर जजेस हैं, चीफ जुडिशियल मजिस्ट्रेट, CJM, ACJM, वो ऐसे जजमेंट्स देते हैं क्योंकि वो वर्क कर रहे हैं दोनों की तरह। Though CJM is a criminal judge, right? But one part of that judgment has to come from the civil judge, or it is of civil nature. तो जब भी हम मोस्टली सिविल टाइप ऑफ अवार्ड्स या जजमेंट्स देते हैं उसको बोलते हैं डिक्री एक तरह से, right? But it has power to be enforced, right? Understanding? It's just like a judgment which has to be implemented. Fine, let's go there. So you cannot seek the statement we have written. Legality in illegality, right? Anything which already has been done wrongly, a procedure which has been initiated wrongly, you cannot claim that you have made a correct law. So you cannot follow wrong procedure to make a correct law, right? You cannot follow correct procedure to make a wrong law. दोनों protected. ये correct है? Fine. Then. ठीक है. अब कुछ typical facts हैं. For example, when you say कि भाई Article 15, 16, right? They are related to what? They are related to no discrimination. Right? So now, kindly compare the statement or the nature, character of Article 14 with 15 and 16. 14 says equality before law. Everybody will be treated equally in front. 15 and 16 have the nature no discrimination. You see how that statement starts and how this statement starts. How do they start? What is the difference in the nature of these two statements? 15, 16 versus 14.
15 they have mentioned no discrimination, but in 16 they have mentioned positive discrimination based upon their.
तो दोनों में लिखा हुआ ना.
We allow discrimination, but how specific?
See, when I say,
but in here discrimination will be done.
In what ways discrimination may happen? Correct. Yes, one aspect is correct, but they have at least provided.
In Article 14, it's much more of a wider term than
General.
But in 15 and 16, are much more specified.
अब ऐसे समझो, स्टेट का काम है सबको इक्वल ट्रीट करना. फाइन. वो सबको इक्वल ट्रीट कैसे कर सकता है? जब वो डिस्क्रिमिनेट नहीं करेगा. नहीं करेगा ना भाई. See, the imposition of equality can only be effective when there is understanding of 15 and 16. 15 and 16 are a special case of Article 14. That is also acceptable, right? But the logic is कि जो starting line है 15 और 16 की, right? The state cannot discriminate. उसका sense क्या है? कि in spite of talking about equality, right? There will be discrimination. Who will discriminate? Not necessarily. People will discriminate against people. Society will discriminate against people, right? And technically the state can also discriminate. So there the logic is that जैसे हम 15 और 16 पे आते हैं, हम क्लियर हो जाते हैं कि स्टेट नेगेटिव है, स्टेट गलत है या गलत हो सकता है. Now see, imagine this is the beauty of fundamental rights. The state has to protect people from its own excess. तभी ये वर्ड 15, 16 में यूज किया, नो डिस्क्रिमिनेशन. भाई हम इक्वालिटी की तो बात ही नहीं कर रहे हैं, हम तो बोल रहे हैं डिस्क्रिमिनेशन मत करो. It's a very logical thing that whether no discrimination means equality. No, that is the idea. You see, we are looking at that equality from multiple dimensions. Fine. तो तुमने बोला सबको इक्वालिटी है, इक्वल प्रोटेक्शन ऑफ लॉ है. फाइन. कैसे है? क्लियर करो. कैसे भाई? ऐसे 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 है. फाइन. ठीक है. तुमने डिस्क्रिमिनेट नहीं किया, किसी और ने किया, then what will you do? So state should not discriminate. State must ensure there is no discrimination. Yes, correct. How to be treated equally despite discrimination. Correct. Logic is that is why we have talked about equal protection of law. So if, try to understand, these identities exist, ये कोई create नहीं करेगा, race, religion, caste, ये कोई create थोड़ा करेगा, it is already there. Yes, it is already there. So when the state is providing the protection or it is treating you equal, तो देखो आर्टिकल 15 और 16 में कहीं नहीं लिखा है कि तुम प्रोटेक्ट करो. Technically protection against discrimination. Discrimination by whom? State, people, this. So logic is कि भाई 15 and 16 recognize that there can be a discrimination on this basis. Already हो सकता है, इसलिए तुम मत करो, तुम प्रोटेक्ट करो. See? So the primary criteria is to first treat everyone equal and then to realize everyone is not equal. Everyone is not equal on what ground? Religion, race, caste. Yeah. So see. So state बोलते हैं कि भाई ऐसा constitution makers say कि भाई see state, you have to treat everyone fairly, right? जहां पे आपको ये अज्यूम करना है कि जो भी आपके पास आ रहा है सब सेम है, राइट? लेकिन एक जगह आपको प्रोएक्टिव होना है, सिर्फ वेट नहीं करना कि सब आ रहे हैं तो सब, राइट? दिस इज अदर, गो एंड फाइंड आउट, डोंट डू इट, right? This is the basis which is already there. This is the discrimination which already exists. Yes, fine, now you're able to understand. ठीक है, ठीक है. Now there is another important technical fact. Okay, now there are articles like 371, 370, 371. चलो 370 to an extent dilute हो गया, 371 है, right? A B C D E F G H I J तक है ना. तो आर्टिकल 371 जनरली फॉर 10 स्टेट्स जो है स्पेशल प्रोविजंस हैं which give them special protection, right? If now under 371, right, up no discrimination on the basis of this place of birth, residence, अब imply हो गया कि when you talk about 371 it is talking about specific regions, you cannot discriminate, right? But nothing can stop the state from making special provisions for socially and educationally backward women and children, for example. So when you use the basis social and educational backwardness, you also start adding another criteria to that. So ये तो already allowed है कि भाई social and educational backwardness you can discriminate. And the state says कि बस yes, as constitution says on the basis of this only. तो मैं only ये basis use नहीं कर रहा हूँ, नहीं, neither मैं combination use कर रहा हूँ. Neither I'm using their combination, nor I'm using them individually. But I am taking this and adding it to socially and educationally backward. What is that? Region, for example. Socially educationally backward in a region. अब ये तो बेसिस हो सकता है क्योंकि neither I have used either of them, nor I have used in combination. So see, when you give reservations to regions under 371D, right? 371D or 371, you can say that way. Then generally for backward regions, backward communities in certain regions, when you give reservations on that basis, it overrides the reservation under Article 15 and 16. It can dominate that. That is why it is a special provision. Fine. So state cannot deny equality. Yes, establishment of Central University in AP, आंध्रा में बिल्कुल. D तो उसी में अप्लाई करता है, but कुछ regions हैं in these states 371, right, which get protection even from the application or even from the violation of these. So nobody can go and claim कि भाई Article 15 and 16 has been violated because of 371 that you have imposed. So in that situation, they will get prominence over 15 and 16, right? So 14 restricts the state from denying equality, right? Denying equality, and 15 and 16 restricts it from discriminating, right? ठीक है. अब 15 में एक प्रोविजन है प्लेस ऑफ बर्थ और 16 में क्या है? प्लेस ऑफ बर्थ प्लस डोमिसाइल एंड रेजिडेंस. Now 16 discriminates it or identifies it separately. Why? Because it can be used as a criteria for giving jobs. Right? If you are not born in a place, but you're domiciled, still you can get benefits of that employment. People who are born automatically may have or claim domicile, and they will get the benefit. So see, it has two meanings. One, that additional criteria under Article 16 is to make sure others are not discriminated. Where technically you should not be discriminated on the place of birth. So if I was born outside this state, I am being discriminated in the jobs. इसलिए वो किया गया कि भाई ऐसा नहीं होना चाहिए, right? आपका discrimination नहीं होगा, right? But secondly, once this criteria is put, we will be able to do a reasonable classification कि जो state का है यहीं पैदा हुआ और जो outside state का है but domicile यहाँ पे. So can we do a reasonable classification unless we define कि कौन यहाँ का resident है, कौन non-resident है, कौन बाय बर्थ यहाँ पे डोमिसाइल्ड है, कौन बाहर से आके माइग्रेशन से डोमिसाइल्ड से. We have to classify. So this is called reasonable classification. It's not discrimination. So many of the people, sons of the soil movement, जो आंध्रा में स्टार्ट हुआ, right? तेलंगाना का भी बेसिकली मूवमेंट वही था बनाने के पीछे. So it was said कि भाई basically the chief ministers are chief ministers of Hyderabad, right? They are not chief ministers of Andhra, or they are not chief ministers of Telangana, but they are chief ministers of Hyderabad. Basically for Naidu, they have said. Fine. So if we want to understand this, let us say that if the discrimination, or for example, you write one line first. Okay. आर्टिकल लिखे 15 talks about place of birth, whereas 16 includes domicile plus residence along with place of birth. Birth. For example, in Andhra or erstwhile Andhra, obviously now Andhra and Telangana, there was a Mulki revolution. महाराष्ट्र में भी हुआ, ठीक है, बहुत सारे स्टेट्स में होता है, हरियाणा में भी और था. In many states it has happened over a period of time, but it basically started there. Mulki revolution or Sons of the Soil movement. अभी कर्नाटका में कर रहे हैं, see, in some other form, but they are doing it. See, so logically, when you say these movements, अब ये movements क्या है? They try to convey the idea that yes, there are special circumstances related to certain regions in a particular state. ठीक है? और इन circumstances जो मणिपुर में वायलेंस है या नॉर्थ ईस्ट में वायलेंस है, उसमें भी एक बहुत बड़ा रोल है, राइट? कि एक थोड़ा सा डेवलप्ड और एक अंडर डेवलप्ड, राइट? So if a region is underdeveloped and people belonging to that region because of that factor are underdeveloped, no road, no railways, no construction, no highways, whatever, they are underdeveloped, fine. Rest of the people are not that underdeveloped. So one regional or reasonable classification within a state is making certain regions, treating certain regions backward and others not backward or normal. ये एक classification हो गया. दूसरा, some people come from outside to the state because the state is becoming more prosperous and developed. अभी इसको समझना, ठीक है, बहुत इंपॉर्टेंट लॉजिक है कि स्टेट में एक पार्ट जो है बैकवर्ड है, एक पार्ट जो है नॉर्मल है या चलो डेवलप्ड है या डेवलप हो रहा है. टू कम टू गेट द बेनिफिट ऑफ दिस डेवलप देयर आर माइग्रेट्स. क्यों? क्योंकि वो ऐसे स्टेट से आ रहे हैं जो 90% बैकवर्ड है, उनके पास अपॉर्चुनिटी नहीं है, ठीक है. बिहार के लोग चलो मूवमेंट कर रहे हैं, राइट? ईस्टर्न यूपी के लोग मूवमेंट कर रहे हैं, फॉर एग्जांपल. नाउ दे आर कमिंग हियर. यू कैन नॉट स्टॉप दिस. राइट टू मूवमेंट, राइट टू रेजिडेंस, फंडामेंटल राइट टू ट्रेड, प्रोफेशन, कॉलिंग, इक्वालिटी, मेनी थिंग्स आर देयर, फाइन. बट अब 16 बोलता है 4 या 4A प्रमोशंस है, तो प्रमोशंस, ठीक है. बट ये प्रमोशंस कब होगा? जब कंडीशंस होंगे. SC ST के लिए अलाउड है, OBC के लिए प्रमोशन एज इट इज अलाउड नहीं है, unless we read section or article 335. we'll talk about it. 335, administrative efficiency is a criteria, right? Without that you cannot just promote people in the organization. Now and try to understand. So these people are moving here, right? These people are moving क्योंकि यहाँ पे भी बैकवर्डनेस है, राइट? और कोई ऐसा ग्रोथ पोटेंशियल नहीं है. ये लोग यहाँ पे आ रहे हैं. ये क्या कर रहे हैं? जो नेचुरल ग्रोथ, क्योंकि ये लोग ऑलरेडी बैकवर्ड हैं. Why they are backward? Because of the region. Are they able to come out of the region? No. Difficult because logistics, support, so many things are missing there, right? They do not have qualification, education, skill. अब यहाँ पे लोग बैकवर्ड हैं, राइट? बट ये मूवमेंट इनकी इजी है. क्यों मूवमेंट इजी है? क्योंकि ये बैकवर्ड है, इनको ग्रो करना है, ये अपने हाउस होल्ड चीजों को छोड़ के आ गए, ये छोड़ के नहीं आ सकते. Imagine this way, right? So whenever the outsiders come from anywhere, right? What they do? They crowd this place. They crowd this place, they take these benefits. So having 371, right, is for that. पहले समझो, for certain regions. अब ये regions backward भी हैं और जो communities हैं वो भी backward है. Region भी backward, लोग भी backward, right? यहाँ से भी जो लोग move करके आ रहे हैं वो भी backward है. Try to, मैं यही कहना चाहूँ, first understand, these people are also backward, they are also backward, they have moved here now, they are all backward, right? But the state says कि people who belong to this, can they be given special benefit because they are backward? Yes, but then they say that we are also backward. But ये तो बेसिस ही नहीं है ना. If you don't belong to the state, then that is not a criteria. Constitution nowhere mentions is that I have to be part of a state to get an employment there. Right? That is why 370 comes. So when the statement we have written that 371D or 371 rules out the reservations under Article 15 and 16, that is the reason. Otherwise ये भी backward है, सभी claim करेंगे, right? तो region को बना देंगे भाई ये prominent होगा. You able to understand this logic? Backwardness, they are discriminating. Yes. So that is the logic of reasonable classification. They are discriminating amongst the same community. That is the logic of creamy layer. They are discriminating amongst the same community. Fine. Are you able to understand? No, you're right. Okay. To understand, this line is also important. To understand the claims of SC/ST under Article 16/16(4)(a), 16(4)(a), for capital A, that is promotions, right? Which 2005 में जो act बना, amendment हुआ, OBC reservation in higher educational institutions, right? It also raised the questions of promotion. 93rd, you can see. See, right, SC/ST under Article 16/16(4)(a) must be read with Article 335. That is maintenance of administrative efficiency. Maintenance of administrative efficiency should be a criteria in giving reservation for promotions. Right. Article 16(4) or clause 4 and 16 clause 4(a). This is very important line, underline it. Do not confer any fundamental right. Any fundamental right per se, this is word is very important, per se on its own, but is like an enabling provision. But is like an enabling provision. That means, see what is, it provides a ground for how they will be applied. Automatically does not generate a right. You cannot go and claim that it is written in the constitution, so I need. It will say no. It is written in the constitution, enabling provision. To implement it, we'll make a law. We'll define the procedure, how it will be done. Right? We will define how classification will be done. How much posts will be reserved. We have defined it. So 16(4)(a) are enabling provisions, right? And not right in themselves. This you remember? Fine. Then reservation, again, within this you write one more line. Reservation to a single post is not valid. Is not valid. Fine. Unless it is a backlog post. Unless it is a backlog post. Right? Or carry forward from the previous years. Yes. So see, can government reserve a single post which is there? No. It will be completely violation. That is why if that holds the validity, the other communities have also been given representation already. तभी तो होगा ना? Right? Previous year vacancies are there. Previous backlog vacancies or carry forward vacancies. For example, like you said, representation. So it was not fulfilled. Now basic criteria of merit will be followed. No, anybody cannot be appointed to that post. No, you will have to qualify basic exam at least. So when you say single post, can a government take out a single post, right, as a competitive exam and say it is reserved? No, it is not correct. MP make High Court ka case hai isliye. Right? A student had already claimed that there is a vacancy and I am qualifying as general category, but because those posts are reserved or those posts were reserved, right, and people have not been able to get the merit and these posts went without filling, right? Then he says, why is it not possible that the posts which are there for general category, right, why can't we increase those posts to accommodate for the administrative inconvenience, administrative inefficiency that will happen if there are people who are actually needed, 10 people, but only 7 are being recruited. Then obviously the administrative task will suffer. Fine. तो उसने बोले कि भाई क्या ये लॉजिकल है कि एक आदमी मेरिट के बहुत ऊपर है लेकिन आप लो मेरिट वाले को ढूंढ रहे हो? तो ये लॉजिकल, किसी कोर्ट ने बोला कि भाई सी दिस रिजर्वेशन इज बियॉन्ड द डिबेट ऑफ मेरिट एंड डिमेरिट. रिजर्वेशन का सबसे इंपॉर्टेंट लॉजिक या रीजन क्या है? हिस्टोरिकल डिस्क्रिमिनेशन को खत्म करना, राइट? बट मेरिट को अंडरमाइन नहीं किया जा सकता. तो उन्होंने स्टेट गवर्नमेंट को इंस्ट्रक्शन दी कि भाई सी काइंडली फाइंड आउट दैट यस these students have performed very well, but because of lack of seats. But if one person is getting selected by 120.5 marks, and another is not getting selected because of 120.25 marks, it's highly illogical, no? And this is true. See, if you say that a person who gets 1175 or 70 is IS or is into UPSC, a person who gets 1166 is not into UPSC. 4 marks you can get in interview, you can get in essay, you can get at any stage of exam. It's a subjective evaluation, no? It's not an objective evaluation. या तो मैथ्स का पेपर होता, साइंस का पेपर होता तो आप बोलते कि हाँ भाई ठीक है, एक नंबर बहुत इंपॉर्टेंट होता है. But where the examiner's perception comes into picture, then how can you even say, give it 3, 4, 5 marks, these are valid marks? Even 15, 20 marks are not valid marks. 20 marks could be a product of lack of understanding of an examiner, could be a product of difference in the examiner's viewpoint. भाई कोई हिंदी का प्रोफेसर है, वो हिंदी की कॉपी देखता है, राइट, और वो तो मार्क्स दे देगा. क्यों? हो सकता है उसके हिसाब से whatever you have written, as per him it is very logical. Right? A PubEd's examiner is there, he is looking into the answer, but PubEd is such a subject that there is no single conclusion about anything. You might have used the term that Taylorism was, or Taylor was not that popular, but Taylorism was. And the examiner may not take it correctly कि भाई कैसे हो गया, Taylor भी बहुत popular था. Taylor led to Taylorism. He might interpret it that way, no? He might say, oh, student's understanding is not there. हिंदी में भी हो सकता है. I'm not saying. I'm talking about any mathematics. It may not be possible. So ये भी एक logic है. So see, merit, criteria of merit is not the primary criteria first. It is to eliminate the historical discrimination. Fine. Next, please. एक और statement लिखिए. Article 17 prohibits untouchability in all forms but does not include prohibits untouchability in all forms but does not include does not include social boycott based on conduct. Based on conduct. Underline this. What does it mean? So if you get a statement in the exam, reverse it. Or let's modify it. If you get a statement that Article 17 abolishes untouchability in all forms, including the social boycott based on conduct. Now you'll never be able to understand कि ये सही है या गलत है. क्योंकि जब वो एक फ्लो में लिखा जाएगा तो वो सही लगेगा. Right? That is how the examiner knows your psychology. Including social boycott based on conduct. अब आपको लगेगा, you'll start interpreting कि हाँ हो सकता है. Right? क्यों? You might think of पंचायत. You must start thinking of village. कि हाँ वहाँ कैसे boycott कर सकते हैं ये तो सही. But that is not the logic. आगे क्या लिखा है? Based on conduct, not based on caste, not based on your race, not based on any other factor which are considered to be social and historical disability. Do you understand this logic? तो social conduct पे आपको boycott किया सकता है, जैसे कि आपको एक ऑफिस से निकाल दिया. Right? You cannot say कि भाई yes I was. अब आप मान लो you belong to let's say a particular community and you go and claim कि भाई I was dismissed from the office or I've been excluded from the office for a week because I belong to this particular community. That was the reason. Right? But because it was done on some other ground, it will not be taken as the reason. Right? वो untouchability नहीं माना जाएगा. एक friends का group आपको बाहर निकाल देता है, उसको आप untouchability नहीं मान सकते. Right? Familial, social relations में if you experience something like that, it will not be treated as untouchability. Fine? Are you getting this point? बिल्कुल. अब तो वो भी नहीं है. तो no discrimination on the basis of gender, sex भी तो है. Right? If it is recognized as third gender or alternative gender, then it is recognized. Why are you taking it? Right? Now see. So Article 20 जो है, right? वो किस लिए है? 20 is for the protection. लिखिए Article 20 right. 20 protection with respect to conviction of offences. 20 clause 1 ex post facto retrospective effect for criminal laws, not for civil laws. ये बहुत typical चीज है. This is complicated. Why? Because when you implement a law ex post facto, right? तो office order law माना जाएगा. Administrative executive orders law माने जाएंगे नहीं. But obviously they will not have force of criminal law. That can only court can do. See? But ये भी logic है. See? Office orders क्या retrospectively impact हो सकते हैं, कर सकते हैं. But their nature should not be criminal again. Right? Executive rules and regulation बिल्कुल हो सकते हैं. Their nature should not be criminal again. Right? Ordinance बना सकता है, yes हो सकता है, but criminal नहीं होना चाहिए. या purely criminal नहीं होना चाहिए. That is also a logic. Is it purely a criminal law or it is a combination of civil and criminal law? तो यहाँ पे लॉजिक है प्योरली क्रिमिनल, और अगर वो क्रिमिनल और सिविल दोनों है तो द क्रिमिनल पार्ट विल बी एक्लिप्स्ड, रिस्ट्रिक्टेड, सिविल पार्ट विल बी एप्लीकेबल. ऐसे भी तो लॉ हो सकते हैं ना भाई जो दोनों हो. राइट, वी हैव टॉक्ड अबाउट, ओके चलो द फर्स्ट लेट्स अंडरस्टैंड दिस. 20 clause 2, no double jeopardy. We have talked about two ideas, ostrophy convict and ostrophy acquit. What does it mean? Well, what does it mean?
One person can be punished 2 times. You can take. It is depending on the nature of the law.
No.
Nature of punishment.
No, see, through the court only once.
Only once. Advisedly.
Yes. Through the court सिर्फ एक ही बार हो सकता है, ट्रायल में एक ही बार हो सकता है. But through other administrative or secondary bodies, through other procedures, he can be tried again for the same thing. So a person committing sexual offense can be tried by this internal sexual offense complaints committee of the organization, and he can also be tried under CRPC or now the BNS, भारतीय न्याय संहिता. बिल्कुल ये किया जा सकता है. Are you getting? So once you are acquitted from the court, you are acquitted. Right? Once you are convicted by the court, you are convicted. But that does not stop you or stop any other organization to initiate proceedings against you for the same crime, provided that it is non-judicial. तो judicial के through एक ही बार हो सकता है, but yeah, appeal हो सकती है. That is not a restriction. Definitely you can appeal against it. You can go to the higher court. Yes, that is also judicial. You can. Fine. Then 20 clause 3, no self-incrimination. Now see, when these protections are available, ये protections क्या है? General protections of all those, right, against whom accusations have started or have been initiated, right? As the formal accusation is made, formal, right? It's not somebody saying कि तेरे खिलाफ FIR लिखवाई जा रही, no. Once it is written, right, as the formal accusation is made, these protections are available both before and during the prosecution. Before and during the prosecution. The process which is going on, right? Evidence gather karna, tumhe arrest karna, whatever. Before and during the prosecution. Fine. Production of liquid. Production of material, objects. Giving blood samples. Etc. is not covered under 20 clause 3. Is not covered under 20 clause 3. That means it is not protected under it. Under it, right? Witnesses do not get protection under 20 clause 3. Oh, they have a specific protection. They get witness protection program, right? But they do not directly get protection under 20 clause 3. Fine. So then, culprit अलग है, victim अलग है, witness अलग. Next point, right? In double jeopardy, 20 clause 2, one cannot be tried for the same offense that means circumstances, materials, facts and nature of crime. Right? See, if the same nature of crime is committed, but circumstances, materials, facts are different, then it will be treated as another crime. Right? So it is not given, you're not protected from the same nature of crime. You're protected from the same offense, or protection is for the same offense, not the same nature of offense. So same offense means one distinct entity, one distinct fact. You killed Mr. A, you killed Mr. B is a different offense. Fine, and you can be tried simultaneously, you can be tried one after another. Fine, now see, right. For distinct offense, one can be tried, one can be tried in a second prosecution after getting acquitted or convicted. Right. That is, it is excluded by the doctrine of ostephoi or ostephoi convict or ostephoi acquit. Right. That is okay. Article 20, Clause 2 only emerges with respect to the punishment inflicted by court of law or judicial tribunals, but does not provide immunity from non-judicial bodies. Right? So from non-judicial bodies you're not protected. Right. Now 20 Clause 3, right? 20 Clause 3, protection against compulsion to be a witness. Protection against compulsion to be a witness against oneself. Against oneself. Right? Now see, read Article 16, 19 again. Freedom of speech and expression also means freedom of silence. Fine? You may not answer. Right? So technically, are we protected directly as a fundamental right of freedom of silence? No. Directly nahi na. Freedom of speech and expression mein implied hai, we will be silenced. We have right to remain silent. CRPC ke provisions hai, right? That we may not be forced to speak without a lawyer. That protection we have under CRPC. Fine? This Article 23 implies that also. That you have right to remain silent. Now if you get a statement in UPSC, Article 19, 1A also implies right to remain silent. Yes. Article 20, Clause 3 also implies that you cannot be forced to speak. Right? Unless you're allowed to have a lawyer. Or do you have an implied right to silence under Article 23? Yes, you have. If you see the American movies, Hollywood movies, they'll say, I take the Fifth Amendment. Right to remain silent. Immunity from speaking against oneself. Anything that one speaks will not be treated as a fact against oneself. मैं उसको ये भी बता दूं मैंने मर्डर किया है तो भी वो फैक्ट नहीं माना जाएगा. Fine? Unless it is done before a magistrate कि भाई this is an evidence I am giving, I killed person. Confession. तभी तो जज हमेशा पूछता है guilty or not guilty. Once you have said you are not guilty, now it is the duty of the state to prove you guilty. It is not your duty to assist the state. So that is the idea. Fine. It is on the principle of natural justice. Finally came. Right. Right to remain silent. लिख दिया. Right to call a lawyer before answering, or before giving any evidence against oneself. This protection is not violated if a person volunteers to give evidence against himself. If a person volunteers to give an evidence against himself, though it will be authenticated before a magistrate. Now see, search warrants, okay, seizure documents, search warrants, seizure documents, etc. Will they be protected under 23? Likho aise. Search warrants, seizure documents, etc. Will they be protected under 20 clause 3? No. No. So see how UPSC will rephrase this. So it will say the search warrants, seizure documents, and other, or the search for other evidences with respect to a crime, with respect to a offense, right? Used for getting information regarding the offense from the culprit's house does not get protection under 23. It will be true. Anything which does not endanger your personal liberty, anything which is not threatening to life, fine? Anything which does not directly establish that you are the one, right, who is incriminating yourself, anything which does not amount to this will not be protected under 23. So an officer can get a warrant to search the house of the culprit or the one offender, right, to get more information. वो 23 में protected नहीं होगा, right? Unless the person gets the injunction from the court. Injunction एक stay order की तरह होता है from the court and say कि see there are a lot of personal things which they should not see. Right? So you may submit the list of those things to the court, and the court will say, fine, if we find these things, you don't have to take them as evidence. They have nothing to do with whatever. So see, is search warrant unconstitutional or violates the fundamental right provided under Article 20? No. Seizure document violates the fundamental right under 20? No. Right? Truth serums, they violate. Yes. Right? Truth serums, lie detector test, right? Simulation test, there are so many things they violated. And that is why they are not admissible in the court of law. Though they are taken as so unless the court permits it, the authorities cannot use them. Are you understanding? Once you acquire a fact or evidence under it, then it may become a ground for conviction, right? But not only the ground for conviction. So based on facts, circumstances, evidences gathered by the people, right? Otherwise, it is one of the easiest method. Get the truth confession. Plus also, the courts have already agreed that it is not, experts have already said, it may be 60 to 70% true and not more than that. So, unko koi absolute evidence nahi mana jata hai court mein. Are you able to understand this? Fine. So see, Article 20 provides protection with respect to conviction of offences for normal offences. Normal offences, which are provided as criminal offences under the normal laws. Fine. Anybody who is found guilty, right, or the prosecution has started against him regarding civil or criminal matters, both get this protection. When you compare this to 22, right? So 22 talks about the protection against arrest and detention in certain conditions. Right? So yes, protection against arrest and detention, that is also a general protection. But here what happens, we make Article 20 more specific in 22. Right? We define that everybody has these protections. Right? You are protected from these application of these things, right? But only when you are an offender under the general law, under the normal law. If you are an offender under the abnormal law, special law, right, sovereign law, that is called preventive detention. Right? Now see, there are two parts. So when you are convicted, an offense has been established or at least initiated. 22 deals with that part, which is similar to 20. Another part of 22 clause 4 to 7, right? That deals with something where you have not committed a crime, you have not committed an offense, but only there is a presumption of committing the offense. So 20 or 22 ka first part deals with when the offense has been committed, right? And a procedure has been started to establish that guilt. Trial is going on. FIR has been lodged. Evidence is being gathered. Procedures have started. But 22(1) part is giving the powers to the authorities even when you have not committed the crime. So that part is called punitive detention, where you are going to get punished by the court of law, and so you enjoy certain protections, so that authority or police cannot misuse that power against you, right? Another part is preventive detention, where you have not done the mistake, but still you enjoy certain protection. Sorry, but still you are arrested, but then you need to enjoy certain protections. So committing an offense and not committing an offense, two parts of 22. Committing the offense and enjoying the protections, normal protections which are available under 20 are also given to 22, right? But that is when you have committed the crime. If the nature of crime is totally different, if the nature of law is totally different, if the nature of act is totally different, then the next part of the 22 applies for the same person. वही पर्सन जब एक अलग टाइप के एक्ट में इन्वॉल्व होता या हो सकता था, yes, then 22(4) to 22(7) will apply. If that person was involved with a normal crime, then 20 and 22(1) to 3 will apply. See? That is called preventive detention. India is probably one of the countries of the world, is a unique country in the world which has such draconian provisions. Not even Germany, not even many of the Middle Eastern countries, none of them have something called preventive detention law. But we don't have to think preventive detention in that sense. Preventive detention can be for ensuring public security, public interest, right? For restricting any act against sovereign. तो ये भी तो फैक्ट है कि भाई आर्टिकल 19 में जो फ्रीडम्स हैं वो restricted है sovereignty और integrity के, right? So anybody who is enjoying a freedom, but by that freedom he may not be able to commit such a crime which may endanger the freedoms of everyone else. So that is why 22 comes into picture. So it is not actually totally against human rights, right? In fact, the idea is that if few humans will be restricted, the other more humans can be protected. But it has proved to be disaster, no doubt, at certain times.
Okay. So you said that कि special provisions के लिए at 20 to general law
कोई भी गलती करता है सिविल या क्रिमिनल की, नॉर्मल पर्सन सिटीजन, उसको हम प्रोटेक्शन देते हैं. 22 में स्पेशल का सेंस है one part is for normal everyone. The other part of 22 is when you have not done anything. So under 22 you can be arrested even when you have not done anything. If you are arrested that way, then what protection is available to you? That is one part of 22. Otherwise, normally जो भी हो जाएगा, see, try to understand, the moment you are arrested for an offense, automatically you enjoy 20 and one part of 22. वो तो automatically आप enjoy करते हो. लेकिन जब आपने offense नहीं किया, then also you have been jailed or you have been controlled by the authority, then what? Then also you need. This can be torture laws. Fine? तो इसलिए वो provision दिया गया कि अगर ऐसा हो तो क्या होगा. Fine? उसमें भी फिर protection है, right? Writ of habeas corpus. You get protection under fundamental rights, right? But you have to establish the fact. Because authorities will put you in jail without anyone knowing it. Then how do you go against it, right? जय भीम देखो. So जय भीम में वही दिखाया हुआ है. Movie, it's a very good movie. Fine. See you then. अभी Monday तो you have the schedule of environment, है ना? Some tests we'll see what test. But कल पवेट क्लास भी है. इन टेस्ट होगा ऐप पे जो हमने पढ़ा है. You don't have to think about, you just have to think what we have done, right? And environment and science tech may be the test, right? What part you have done? Ecology, definitions and all you have done. It can be both, it can be one paper. वो information चला जाएगा, but we want to give 100 questions. Let's see, right? But we cannot just want to give questions out of any book. So we make questions, right? When we'll make questions, it will take time. So timing क्या होगा वो आपको बता. The moment it will be uploaded, you will be given 2 hours or 1 hour, whatever be the nature of test. Attempt it and then submit it. That is the best way, right? No need for paperwork. ठीक है. See you then tomorrow.
Introducing the Prelims Target course and Prelims test series at ProdEgyIAS. Designed for UPSC Prelims 2026, this comprehensive program offers in-depth classes on history, geography, science and tech, environment, polity and governance, and economy. Stay updated with current affairs and sharpen your skills with our Prelims test series consisting of 50 full-length tests covering all subjects along with CSAT. Join ProdEgyIAS and stay ahead.